Ready for legal dictation. Start. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 14/11/2018 passed by the High Court of Judicature at Allahabad in writ petition number 33482 of 2018, by which the High Court has dismissed the said writ petition preferred by the appellant herein and has confirmed the order passed by the presiding officer, Labour Court for UP Kanpur Nagar under section 33C Bracket 2 of the Industrial Disputes Act. The original writ petitioner has preferred the present appeal, that respondent number 2 herein moved an application before the Labour Court under section 33 bracket C bracket 2 of the Industrial Disputes Act in miscellaneous case number 26 of 2012, demanding the difference of wages from 1/04/2006 to 31/3/2012. The said application was contested by the appellant herein denying any relationship of employee-employer. It was the categorical stand of the appellant that respondent number 2 herein was never engaged by it before the Labour Court. Respondent number 2 herein relied upon the documents Exhibit W1 to W6 in support of his case that he had worked in the establishment as a salesman, that by order dated 28/11/2017, the learned presiding officer, Labour Court, allowed the said application and directed the appellant herein to pay the difference of wages from 1/04/2006 to 31/3/2012 as claimed in the application. Feeling aggrieved and dissatisfied with the impugned order passed by the learned presiding officer, Labour Court under section 33 bracket C bracket 2 of the Industrial Disputes Act, the appellant herein preferred a writ petition before the High Court by the impugned judgment and order. The High Court has dismissed the said writ petition, which has given rise to the present appeal. Shri Vishal Yadav, Learned Counsel, appearing on behalf of the appellant, has vehemently submitted that in the facts and circumstances of the case, the High Court has erred in dismissing the writ petition and confirming the order passed by the Labour Court under section 33C bracket 2 of the Industrial Disputes Act. It is submitted by Shri Yadav, appearing on behalf of the appellant, that the High Court ought to have appreciated that when there was a serious issue raised with respect to the employer-employee relationship between the appellant and respondent number 2, and that it was seriously disputed that respondent number 2 was at any point of time in employment as a salesman, the Labour Court ought not to have entertained allowed the application under section 33 bracket C bracket 2 of the Industrial Disputes Act, as the same could have been decided in the reference under section 10 of the Industrial Disputes Act. It is therefore submitted that the order passed by the Labour Court is completely without jurisdiction. Therefore, the High Court ought to have set aside the same. Reliance is placed on the decisions